Uh, See, this is a provisional specification. There is no such thing called provisional application. What we have is provisional specification. So, let's say you develop something, you have an idea, and you still require time to develop your invention. You require more than 4 5 months to work that invention to find if it's really workable invention to develop something called a prototype. What you can do is you can write down that idea on a piece of paper, maybe 2 3 pages, and go and apply for a patent along with that 2 3 pages of specification, what we call as provisional specification. The provisional specification will just give you an overview of the invention. It need not explain the invention in detail. It need not describe the invention in detail. You don't have to provide any drawings. You don't have to provide any claims for invention. You don't have to give them anything. You will have to just give it disclose what you think your invention is, and you will get a date and you will get an application number. This application number and the date is the same for the complete specification, whatever it is. Even it remains till you get a patent. Then you get a patent number. So therefore, this application number and date, what we call as priority date or priority number. So you will have this. This is actually very very important for inventions which are not complete. Okay. Generally, I advise using provisional specification for individual applicants. You don't lose anything, or you still have time. Let's say sometimes what happens is you may have to present a paper in an international conference. So before doing it, what you can do is you can apply for a application along with the provisional specification and go ahead and make present your paper wherever you want, or send it for publication to a journal. The number and date will not change throughout the life of a patent or a patent application. So complete specification, I told you, after you have filed provisional, within 12 months, you'll have to file complete specification. Or if your invention is complete, you can directly file the complete specification. Whatever the case may be, complete specification means it should fully and particularly describe the invention. It should completely describe the invention. You should not leave out anything. Maybe, it need not be something called a manual, operating manual. You don't have to explain, you'll have to connect a wire to it, and this wire will have to be connected to a socket or something. They are, what you find in manuals when you buy a refrigerator or a washing machine. This is not a manual. It is actually addressed to a person skilled in that. You will have to have some knowledge reading the specification, addressed to him. So there, I'll just show you some sample specification. So you'll have to explain what is already known and what is the difference that you come up with and what is your invention. Okay, you'll have to claim what is your invention. Claim is what we call as boundary of the invention. Okay, it gives you exact boundary what you think your invention is. I'll just show you, a sample specification now. Okay, this is how complete specification will look like. Okay, this is the invention that we spoke about earlier regarding the gas leak detector. Okay, and this is for a company called Digas. You will have the applicant name there. There are 4 5 inventors for this application. You will find that information in form 1. Here you'll have to just mention the applicant name. What is the field of the invention? To which field this invention relates to? It relates to a system to detect gas leak from gas stove burner. Okay, the system senses any gas leak from the gas stove burner and automatically shuts off the gas stove. So this is the field of invention to which your invention relates to. Okay, and background art. Background art in the sense, what is the state of art that you are aware of? What is the current scenario in your field which the invention relates to? What is known to you? This background art you can give or you don't have to give. If you are aware of it, you can disclose that. If you're not aware of it, there's no requirement for you to provide that. Okay. Sometimes what we do is we identify, certain prior US applications or European applications, Chinese applications, whatever it is. We explain this is what is the known art, what is the known invention currently, and how my invention is different from that. What are the drawbacks associated with it? The idea of giving a background art is what are the drawbacks that is associated with prior art, and what is the solution you're giving for the existing problem. Okay. So what we have done is we have given 2 patents here, one a US patent and another Chinese patent. Okay. Now here the later paragraph we have tried to explain what is the problems that are associated with the prior art. Okay. We told them it is very complex. there is a need to develop a non-electronic, non-electrical user-operable device. So this is a problem that we are going to address. Okay, we give something called a summary of invention, what your invention actually means. Later, brief description of the drawings. You'll have to give the various drawings, that relates to the invention, and you can 1 or 2 lines you can give describe the drawings. For example, it shows a perspective view of an embodiment. It gives you another view. It gives you a top view. It shows a schematic illustration. It gives you side view. It gives you front view. Whatever it is, for the someone who reads the specification will have to know when he looks at the drawing what is he looking at. So for that purpose, this particular brief description is actually required. Then you go to something called detailed description of the invention. Here you describe the invention in detail. We explain everything, how this works, how this operates, by referring back to the drawings. You would have provided drawings. I'll show you drawings. You would have provided drawings. By referring back to the drawings, what you'll do is you will explain this invention in detail. For example, in the drawing for each of the parts, we would have given numbers. For example, temperature sensor as number 2. Okay, and burner the number is 1. Latching rod number is 4. Connecting rod number is 3. The strip bimetal number is 2. So we have numbers for all these things. Okay, and using that number, we try to explain the invention in detail. You can give examples also. You can give cases also. You can give working models also in the description. This is the most important part of the specification, what we call as claim. Generally, when you talk of claim, what we understand is what you claim as an invention in the sense, we see people writing, this is my invention, no one has invented it before, this can do this, it can do wonders, it can do this and that. The idea of claim in a patent specification is not that. It gives the boundary of the invention. In a single paragraph, you'll have to claim what is your invention. If you just look at this particular claim, you will know it is a device. I'm talking of a device. I'm claiming a device. We claim. The company Digas claims a device to do what? For automatically switching off a stove. What does it have? Having a fuel control now. Other things. Okay. Now the device. When I explain what is it of, then I go ahead and design this additional feature that I add to an existing gas stove. I say this device comprises of. We use the word compressing. Comprises of. What all they have? They have a bimetallic temperature sensor. They have a position close to a burner, a connecting rod connecting to the temperature sensor, to a latching rod, a spiral spring loaded to ratchet wheel. Now you'll find each of these particular parts are connected. Their parts. For example, temperature sensor is positioned to a burner. Okay, there is some positional spatial connection there. A connection rod connecting the temperature sensor to a latching rod. So the purpose of connecting rod is to connect temperature sensor and a latching rod. So it is not like a geometry box. In a geometry box, you will find the divider, compass, scale, but whatever it is, separately, they just strewn around there in a box. Nothing is connected there. It is not a geometry. You're not claiming a geometry box. You are claiming a product. You will have to explain how each of these parts that constitutes this particular product are connected to each other, either position wise or by physically. Physically, how one is connected to another, how part A is positioned vis-a-vis part B. So these things you'll have to provide in a claim. If you just go and do a Google search, you will find a lot of specifications. When you read 1 or 2 claims, you'll understand what is expected in a claim. You can have any number of claims that particularly points to the particular invention. You can have a device claim. You can have a method claim. So here what we have is, we have both the product claim. Device in the sense it's a product. I'm claiming a product. A device is a product. I'm also claiming a method of switching off a gas stove using this particular product. So device also, I've got a patent, and I also have a patent for the method also. So if someone is using this product, but making something similar, using it, I'm protected both ways. You cannot use it without my permission. You cannot manufacture it without my permission also. Okay. So you end with an abstract. Yeah, abstract is similar to summary, but it is much shorter than a summary. It has to be less than 150 words. This is the drawing. They've given us a 3D drawing. You don't have to give 3D drawing. It can be kind of a line drawing that explains, shows what is your invention is. various views they've given you, which the description, a brief description of each of them we provided in the description. Application fee, other things, Mr. Udeshankar will cover. But to just give you an idea, it is 1,600 for individuals and 8,000 for companies and institutes. Along with the application, or within 48 months from the date of application, you'll have to file something called a request for examination. Then only the patent office will examine it. Otherwise, it will not examine it. The application will just remain there. Okay. For that, for it is 4,000 for individuals and 20,000 for companies and institutes. And this fee, when you ask for an express examination, is different. This is ordinary examination. As I told you, there's no international patent. There's no world patent. But what you can do is you can file an international application for a patent. Okay. In the sense, you invent something in India. Okay. Rightly speaking, before the Paris Convention, you will have to apply for that invention in India and any other country you want patent for at the same time, same moment. See, today you file in India, tomorrow you cannot file in US. So when the US application is taken for examination, the examiner will say at least one day before your date of filing, there's already another application pending before the Indian Patent Office. It is published. So you cannot go and argue, no, that is my application. That is not allowed. Okay, you'll have to file at the same time. So when that became an impossibility, what countries thought, they joined together and came up with something called a Paris Convention. Using the Paris Convention route, there are about 130 member countries there. You have 12 months time to file in any of the member countries from the date of your filing in India. Okay, so India you file today, within 12 months you can file it in the US, you can file it in Europe, you can file it in Japan, you can file it in China, you can file it in Egypt, wherever you want you can file, but still you will get the priority date and the filing priority date and priority number that you filed in India. The Indian date will be valid. You will get a different number there, you will get a different filing date there. But your priority date, in the sense, when someone conducts a search to find if your invention is novel or not, he'll have to use the date of filing in India, not the date of filing in the US. Okay, I file it in June in India. In August, I'll file it in the US since there is 12 months time. So when the US examiner takes your application for examination, he will not use if there are any inventions available in the world before the date of filing in the US in August. Okay, August is data filing, right? You will not conduct a search before August. Instead, you will conduct a search before June because you filed the application in India in June. Okay, so you get 3 months in between. If some other inventions were filed between the 3 months, you are protected against those inventions now. Okay, this is Paris Convention. This is what we call as convention application. You file it in India, within 12 months, you individually go and apply in each of these member countries. Now later, another treaty came into being. They are not competing; they are actually complementing each other. You can use any of this way. You can use the Paris Convention route, or you can use the PCT route. PCT means Patent Cooperation Treaty. Here, what you do is, after filing in India, after filing in one of the countries, within 12 months, you file something called an international application for a patent. When you file an international application for a patent, you get filing date, you get priority date in about, again, 130 member countries. 120 to 130 countries are there. You get the priority date in all the member countries. Okay. You don't have to go and individually file there. You just get a date there. You get a date there. That means only you can file applications there. Now they give you, instead of 12 months, they give you 30 months. Within 30 months, you can elect any of the countries. You can say, for example, you got a new invention to drill coal, okay, for mining coal. There are many countries where coal is not available at all. Okay, you don't have to go and file there, right, to get a date. So out of the 130 countries, what you can do is, where there's a market for my invention, for example, two-wheeler. Two-wheeler is a huge market is in India and Southeast Asian countries. Okay, you develop something, you come up with a new invention for a two-wheeler. You can, what you do is you file an international application of a patent. You get filing date in all these countries, priority date in all these countries. Then you have 30 months to do a commercial study there, market study there in each of these countries. Then determine which of the countries you want, you're going to enter. Then only in those countries you need to file application for a patent, and you will get a patent in those countries. So this is what we call as PCT. with this, I've come to the end of the session. I'm not sure whether I was able to cover most of the things that you were expecting, but still I can cover other things by answering one or more questions from you. If you want, Madam wants, I can answer certain questions here, or we can take these questions later at the end of the workshop also. That depends on your thing. Yes, ma'am, I'm done.
Hello, sir.
Hello, ma'am.
Any questions from the participants? Mute. If any participant wants to raise question, please raise your hand so that we'll unmute you. Participants, if you've got any queries, please raise your hand. Participants, any questions from your side? Participants? Sir, am I audible, sir? Rajshekhar, sir?
Yes, ma'am, I can hear you.
Yeah,
Yes, yes, I can.
Okay, sir.
I can hear you.
Okay.
You want me to stop sharing the screen?
Yeah, sir. So in that case, we can, I think there are no questions from the participant side.
Okay.
We can.
I saw some people raise their hands during the session. I can answer your questions also.
Chat போங்க. Sir, yeah, you can post your questions also in the chat box.
Sir, Dr. Singaravelu வந்து ஒரு question கேட்டிருக்காரு sir.
என்னம்மா?
Dr. Singaravelu.
There are actually 2-3 questions, ma'am, in the chat box.
Yes, sir. Sir has got, he's asking.
Can we get a pattern for products which are already in the market? Example, Nescafe for instant coffee. Okay, that's a good question actually. See, in the sense, what is already in the market, you cannot get a patent. But what you can do is you can make modifications to an existing product which is in the market and get a patent. For example, if you just look at this Nescafe soluble coffee powder, instant coffee powder, okay, and that is different from brew coffee, right? The taste, the flavor, everything is different. That means the particular compound which they made, the coffee powder which is made, is different from Nescafe coffee powder. The process would have been different. The ingredients would have been different. The temperature, the pressure, the various parameters, everything would have been different, the way they made it. Okay, so you can get a patent for that also. So Nescafe itself would have, would be owning about 10 to 15 patents on instant coffee. I can just search and I can show you. For example, say, think of engine. Engine is something which we know, right? Okay, engine is will have about 20 to 30,000 patents on that. So every modification, it may be the piston ring or the way the movement happens, the way valve opens, whatever you can think of, you file a patent for. So you shouldn't look at some product company by itself. But still there are many that make particular product, many essential elements that make the product. Every modification they take to it, you can get a patent for that. Product itself cannot be patented, but when you make modifications to it, when you make substantial additions to it, validation to it, you can get a patent for that.
Rajshekhar sir, Dr. Singaravelu has got a question.
Yes, sir. Sir, suppose one organization have a symbol for their organization
Correct.
Can it be made as a patent, sir? Suppose, say, example, Apollo has got a symbol. So, if similar hospital starts somewhere, can we use that symbol? It should be patented like that. For any smaller organization, they have a symbol for their own organization, which can be patented or should be applied for patency like that.
Sir, sir, if I understand your question correctly, the Apollo name is not a subject matter for a patent, sir. It is a trade.
A trade. Yes, sir.
Okay.
Trade.
So,
That,
sorry, sir, I'm not able to hear you. Please go ahead, sir.
The trade can also, the trademark also can be patented so that this trade cannot be, that symbol cannot be used by others. Just, I
No,
want
trademark cannot be patented, sir. Trademark can only be a trademark. It can be registered as a trademark because in a for a patent you need a tangible product at the end of any process. For example, medicine, a drug or a stethoscope or anything, a tangible product which I can see. Whereas this is trademark distinguishes one services to another service or one product to another product. Okay,
Thank
so
you.
Apollo Hospital is distinguished with other hospitals by their trademark.
Thank you. Thank you.
Rajshekhar sir, there is a question from Dr. Amal Dongre. Can we file copyright for course materials, PPTs, and workshops, workbooks,
Yes,
etc.?
Yes, you can. For anything, whatever you want.
Okay.
The copyright office is in Delhi. All you have to do is take a printout of that, whatever material that you're thinking of, and send them 3 copies.
Okay.
So what they'll do is they'll give you 2 copies and send you, put a seal, copyrighted, and send you 1 copy back to you. But at least course material and workbook, if you're going to publish it, you don't have to register it. All you have to do is just mention the year of copyright and who owns this copyright. For example, Mr. Dr. Amal Dongre, 2020, copyrighted. That is more than sufficient.
Okay, sir. So there is a question from Dr. Narayanan. Can we make patent filing for plant as isolated products?
No, sir.
No.
No, it is not. As I told you, plant varieties you cannot get a patent, but microorganism you can get a patent for that. Whereas if you got a microorganism where there is a human intervention, this microorganism does not exist in nature. There is a microorganism that exists in nature, but what happens is you modify it, you genetically modify it. You can get a patent. In fact, the genetically modified products, you can get a if it is genetically modified and there's a complete intervention there, this particular DNA is not available in the nature to modify it. For that, you can get a patent.
Okay, sir. There is a question from Dr. Raja Parthiban. Is there any search links for Indian and US patent search?
Yes, sir. You have, sir. Or you don't have to go. I mean, all these patent offices, Indian patent office has their own search facility. US patent office have their own search facility. European patent office, again, they have their own search facility. Google has come up with a very good patent search engine. Okay. So using Google patent, if you want, I can send you the link. I can, let me just share the screen. Maybe, I can just show you Google patents. In any case, we are planning to take one search session later in the afternoon. But let me just show you.
We'll do it in that session.
Can you see the screen?
Yes, sir. Yes, sir.
So this is Google patents, sir. You'll find Google patents. Okay. What you can do is, let's say you're going to search for something. I'm searching for a diesel engine. So all you have to do is enter DI. Okay. Now, see, if you just look at the engine, you have some 85,000 85,000 patents on that. Okay. Now I can limit it to something. Okay. this I can add
இது வந்து பப்ளிஷ் மட்டும் தான் வருமா?
அப்படிதான் நினைக்கிறேன்.
here. I can add petrol.
Okay.
See, the 87,000 has gone down to 67,000. Okay. Now still I can keep on adding. For example, I can add something like what would I say? Ring. Say it has gone down to 70,000. So what you have to do is you can keep on adding keywords into it, and finally come up with something. You will end up with 1,000 to 2,000 specifications, applications. You can open each of them to find whether it relates to yours. For example, I'm talking of ceiling ring. Now it has come down to 46,000. It could be something like a rubber ceiling or something.
Okay, sir.
So you're using Google Patterns, you can do this, come up with this.
Okay.
So when you open this, one of the specifications, you will find the inventions there. Everything you'll find. You'll find background of the invention, specification. You'll find the claims. You'll find drawings. You'll find everything here. Okay.
Yes, sir. Rajshekhar sir, one last question.
Yes, ma'am.
Can we patent an existing product which is made as a new product with a slight modification in the design?
No. What we call them as workshop improvement. Workshop improvement cannot be patentable.
Okay, sir. Okay,
so,
sir.
it is just modification in the outer design. It is not making any value addition to the product. You are not making substantial addition to that. Okay, only when you make that, maybe you can even remove one element from it and still it works better. That can be a subject matter of a patent. But otherwise, you cannot make any changes to it.
Okay.
Actually, there is a very good question here, ma'am.
Okay, sir.
Teaching method cannot be patentable.
Yeah,
it's not patentable.
It's not tangible, right?
It's not tangible. You don't have any. It's not industrially applicable. Also, you cannot get a industrial product also out of it. Okay. And the simulation model again is not patentable because you have a software that runs on your computer. You give the inputs to it and gives you a simulation model. Absolutely, there's no output also there. You can see it visually. It cannot be patented here in India.
Okay. So we'll stop with this. Uday Shankar sir is waiting. Thank you, sir. We'll be back in the afternoon session. Thank you, participants. We have shared you the link for the next session. Please join us in the meeting with that link. Thank you.
Thank you.
Thank you, sir.
Thank you.
Stop on it. Me on the link.